In the fast-paced world of Indian business, the spotlight often falls on innovation, market share, and profitability. We celebrate the unicorn valuations, the disruptive technologies, and the charismatic founders who steer their ventures to unprecedented heights. Yet beneath this visible surface of commercial success lies a complex and powerful architecture of laws and regulations. This legal framework is not merely a set of restrictive rules or a bureaucratic hurdle to be overcome. Instead, it is the very foundation upon which sustainable, ethical, and resilient enterprises are built. Understanding this architecture is no longer a task to be delegated solely to the legal department. It has become an indispensable skill for every manager, entrepreneur, and professional who aims to lead and succeed in today's intricate economic environment. Think of business law as the operating system of the commercial world. Just as a software developer needs to understand the underlying code to build a stable and scalable application, a business leader must grasp the principles of corporate, financial, and exchange control laws to build a durable organization. These regulations govern every critical function: how a company raises capital, how it expands overseas, how it deals with investors, and how it maintains transparency. Ignoring these rules, whether through ignorance or willful neglect, is akin to building a skyscraper on unstable ground. The initial progress might seem rapid, but the structure is vulnerable to shocks and destined for eventual collapse, carrying with it the investments, careers, and reputations of all involved. The first pillar is the Foreign Exchange Management Act, 1999, or FEMA. This is the grammar of all cross-border transactions. FEMA dictates how money can move into and out of India, defining who is considered a resident, what constitutes a current account transaction for trade and services versus a capital account transaction for investments, and the critical gatekeeping role played by authorized dealer banks. Person resident in India, PRI. FEMA's residency hinges on period and purpose of stay, not just tax days. Different tests apply to individuals versus entities. Current account transaction, payments for trade in goods, services, travel, education, remittances for living. Generally liberal, subject to rules. Capital account transaction, those that alter assets or liabilities outside India of PRI or in India of persons resident outside India. Regulated, restricted. Authorized dealer, AD bank. Your operational bridge to FEMA. They verify purpose, documents, pricing, and beneficial ownership. LRS, individuals. Annual window for eligible remittances, education, travel, investments, subject to purposes and tax collection rules. ODI, entities, individuals, where permitted. Investment in JV DUOS abroad, comprising financial commitment, equity plus debt, plus guarantees and pledges. Guardrails include eligibility, sectoral limits, round-tripping concerns, and time-bound reporting. Routes: automatic versus approval, caps conditions by sector. Instruments: broadly non-debt, equity convertibles versus debt, ECB. Pricing, valuation rules apply. Reporting: issuance transfer within timelines on designated portals. Maintain BO transparency. Manager's compass. Always run a 5-step. 1. Classify transaction. 2. Check route cap. 3. Confirm pricing. 4. Collect docs. 5. File forms on time. Offshore structuring can be legitimate when it serves clear business purposes, is transparent, and respects Indian exchange control and tax rules. The law rewards substance and disclosure. It penalizes form without substance and concealment. Offshore company. A body corporate incorporated outside India, for example BVI, Cayman, Singapore, Delaware. Used for holding investments, raising capital, owning IP, or running regional operations. Tax haven. A jurisdiction with low zero taxes, high confidentiality, and light regulation. Some also provide robust courts and flexible company law. Tax avoidance versus tax evasion. Avoidance stays within law, structuring to minimize tax. Evasion is illegal, concealment, misreporting. Indian law constrains avoidance through GAR and specific anti-avoidance rules. GAR, General Anti-Avoidance Rules. allows authorities to disregard or recharacterize arrangements whose main purpose is a tax benefit and which lack commercial substance. For example, round-tripping, accommodating parties, non-arm's length elements. POEM, place of effective management. A test for residency of foreign companies. If key management and commercial decisions are actually made in India, the foreign company may be treated as resident in India, global income taxable in India. Substance. The genuine people, premises, decision-making, and risks in the jurisdiction of incorporation, the opposite of a paper shell. Access to global capital. Many investors, VCPE, sovereign pension funds, invest via familiar hubs. Offshore vehicles can simplify cap tables, rights and exit mechanics. Neutral governing law and courts. Predictable common law systems, for example, English law style, for shareholder agreements, financing and enforcement. Currency flexibility. Easier to raise USD/EUR capital, list, hedge and do international M&A joint ventures and IP holding. Neutral ground for multi-country partners, ring-fence IP with licensing back to operating entities, subject to transfer pricing and withholding rules. Regional management, a hub for Asia, MEA operations where execs actually reside and work. Using offshore for these reasons is not unlawful. It becomes risky when Indian money quietly leaves and returns, round-tripping, when decisions are really taken in India, POEM, or when structures exist only for tax, GAR. ODI, Overseas Direct Investment. Indians, companies/LLPs/others as permitted, may invest in JVYOS abroad within financial commitment limits, equity, loans, guarantees, pledges combined, subject to eligibility, sectoral rules, and time-bound reporting, post-investment and annual. Round-tripping sensitivity. Direct or indirect structures that route Indian funds out and back into India via an offshore entity can attract scrutiny. Approvals may be required or the route may be constrained. Disinvestment, sale, write-off and closure are regulated. Ensure valuation and repatriation rules are followed and filings are on time. LRS, individuals. Residents have an annual remittance window for specified purposes. Investments are subject to caps, purpose checks, and tax collection rules. POEM. Track where boards committees meet, who makes approved strategy, where the head office is, and where senior management actually work. Patterns that centralize control in India raise POEM risk. GAR. Maintain a commercial substance memo showing non-tax drivers, investor access, law courts, currency, governance. Avoid circular flows and accommodating parties. Transfer pricing and DEMPI. If offshore holds IP or finances the group, ensure arm's-length pricing. Align with functions, assets, risks actually performed, development, enhancement, maintenance, protection, exploitation of intangibles, indirect transfer. Sale of shares in an offshore company that derives substantial value from Indian assets can trigger Indian tax. Factor this into exit planning. SBO, significant beneficial owner, and BO transparency. Indian companies must track natural person controllers. Counterparties increasingly require beneficial ownership certifications, related party and governance. Intra-group dealings with offshore affiliates may need board shareholder approvals and arm's-length support. UPSI and disclosure when offshore vehicles sit above a listed Indian entity. Maintain clean insider lists and avoid back-to-back leaks across jurisdictions. People. Directors, executives who reside in the jurisdiction and actually run the entity. Local company secretary, administrator. Premises. Dedicated office, not just a registered agent's address, suitable for the functions claimed. Decisions. Board committee meetings held there. Minutes reflect real debate and decisions. Avoid rubber stamping India-made calls. Operations. Local bank accounts, service provider contracts and records. Third-party customers or vendors where consistent with the business. Documentation, travel logs, board packs, policies and org charts that corroborate decision-making outside India. Why BVI is often chosen. Quick incorporation, flexible share classes, ordinary, preferred, redeemable. No local corporate income tax, modern company law, common law courts, and straightforward M&A mechanics. Formation at a glance. Engage a licensed registered agent. Draft memorandum and articles. Appoint directors. Issue shares. Maintain statutory registers. BVI has a beneficial ownership secure search system and an economic substance regime, VC investment holding. Indian promoter sets up Indian OpCo. Investors prefer to invest into a BVI holdco that later owns OpCo. Indian side. If Indian residents fund/guarantee/own the BVI holdco, comply with ODI LRS valuation norms, beneficial ownership declarations, and maintain POEM separation. IP holding licensing. BVI entity acquires group IP and licenses to Indian OpCo. Indian side, ensure arm's length royalty under transfer pricing, withholding tax handled, FEMA approvals, filings, substance for DEMPI functions, exit considerations. Sale of BVI holdco shares can create indirect transfer exposure in India if the BVI company's value is substantially derived from Indian assets. Buyers' lenders will ask for tax rulings, warranties, plan early, red flags, BVI, post-box companies with all decisions made in India, POEM risk, funding that leaves India and returns as foreign money, round-tripping, absence of BO records, and no economic substance where required. Global tax reforms, BEPS 2.0, Orientation Guide, Pillar 1, reallocates part of residual profits of very large multinational groups to market jurisdictions where customers' users are located, regardless of physical presence. Pillar 2, introduces a global minimum effective tax, commonly referenced at 15%, for in-scope large groups, implemented through top-up taxes in parent intermediate jurisdictions, reduces incentives to park profits in zero-tax entities without substance. Implication: for sizable groups, pure tax rate arbitrage via havens becomes harder. Commercial substance and value creation drive outcomes. Indicators of problematic structures, red flags. Funds exit India and re-enter as foreign investment. Back-to-back guarantees, circular share transfers, centralized decision-making in India. Controls, make good governance visible. Pre-transaction legal memo. Board calendars and minutes in the offshore seat. Independent valuations, ODI, FDI reporting trackers. Before you incorporate offshore, business rationale, non-tax. Investor needs, governing law, board composition, seat of management. ODI, LRS eligibility and caps, pricing, required approvals, bank readiness, draft substance plan. During the life of the structure, keep meetings and decisions in jurisdiction, maintain registers, renew licenses, file annual returns of substance reports, monitor related party flows and TP compliance, refresh BO, SBO and customer KYC certifications. At exit closure, plan for indirect transfer exposure, obtain valuations, evaluate treaty relief if applicable, make tax FEMA filings, repatriate proceeds per rule, close accounts and deregister. SEBI Act 1992 establishes the Securities and Exchange Board of India, SEBI, as the market regulator. Securities Contracts Regulation Act 1956, SCRA, provides the statutory framework. Depositories Act 1996 enables dematerialized holding. Companies Act 2013 intersects on prospectus liability, dispute and appellate structure. SEBI's orders are appealable to the Securities Appellate Tribunal, SAT, and further to the Supreme Court on points of law. Core SEBI rulebooks, LODR, PIT, SAST, PUTP, ICDR, Security, SCURA Section 2H, includes shares, scrips, stocks, bonds, debentures, derivatives, units of mutual fund schemes, AIFs, government securities, and other notified instruments. Material event information, LODR Regis 30, information that a reasonable investor would consider important, plus the specified events listed in Schedule 3. Disclose events arising from board decisions within 30 minutes, within 12 hours, within 24 hours. UPSI, unpublished price-sensitive information, PIT, non-public information that would likely materially affect price when published. UPSI binds insiders and triggers trading window closures. Connected person versus designated person. Connected captures anyone with a relationship enabling access to UPSI. Designated is a risk-based subset mandated to follow additional internal controls. What LODR does? LODR hardcodes the continuous disclosure regime and the governance scaffold for listed companies. It treats disclosure as ongoing, not episodic. Common pitfalls and fixes. Pitfall: late or skeletal reg, 30 filings. Fix, pre-drafted templates. Pitfall, treating analyst calls as informal. Fix, publish the presentation. Company-level controls, trading window closures, pre-clearance and contra-trade monitoring. Structured Digital Database, SDD. Immutable logs of UPSI sharing. Why it matters. Enforcement hinges on documented controls and SDD integrity. A strong audit trail and need-to-know access discipline are your first line of defense. When does an open offer trigger? 25% voting rights. Acquiring 25% in a listed company triggers an open offer. Control. Acquiring control can trigger an offer even below 25%. What PFUTP bans? Manipulative or deceptive devices, wash trades, circular trading, spoofing, layering, marking the close, pump and dump. How it is enforced. SEBI may issue interim directions. Intent can be inferred from patterns, communications and alignment with disclosures. Key documents and stages. DRHP, Draft Red Herring Prospectus. RHP, Red Herring Prospectus. Prospectus. ASPIE, application supported by blocked amount. KRA, KYC Registration Agency. Repositories where intermediaries upload investor KYC. KRAs validate attributes and synchronize with the Central KYC Records Registry, CKYKR. Risk-based KYC. Classify investors, low/medium/high, based on customer type, geography, product risk, PEP status, and adverse media. Managers compliance toolkit, quick reference, disclosure calendar, pit control room, SAS trigger memo, PFUTP surveillance, KYC ops. A targeted deterrence and asset recovery statute. If a person accused of specified economic offences of Rs 100 crore or more remains abroad and refuses to return, a special court may declare them a fugitive economic offender, FEO. The Act complements PMLA and extradition laws by addressing the jurisdictional gap created when an accused evades Indian courts. Fugitive Economic Offender, FEO, a person, I, against whom a warrant of arrest is issued for a scheduled offence (URS), with an aggregate value of at least Rs 100 crore, and 2, who has left India to avoid prosecution or, being abroad, refuses to return. Scheduled offences. Predicate economic offences listed in the Act's schedule. Application by the Director, Enforcement Directorate, ED. Notice to appear, hearing and declaration. Confiscation and administration. The court may order confiscation to the central government of A. proceeds of crime and B. other properties of the FEO,